Now we're on to contract basics. So contract law is formation and enforcement of contracts. If you're taking the property and casualty or personal lines test, that would be breach of contract, which would entitle the injured party to damages, attorney fees, and cost. If you're taking the life and A&H test, it'll just be a multiple choice answer on your test. Or it could be a test question that says what pertains to formation and enforcement of contracts. Now, tort law is definitely going to be on your property and casualty test, but we will go over more of that in your property and basics here, and property and liability basics. Tort law on your life and A&H test will just be a multiple choice answer to eliminate, and tort law is just establishing who did harm to someone else, and if you're found responsible, you're obligated to pay. So it excludes breach of contract and criminal acts. Now, elements of an enforceable contract, that's ACCL, which is agreement, offer, and acceptance. Then consideration, which is an exchange of values. Competent parties means who can enter into a contract. Just remember who's restricted or minors under the influence and mentally incompetency, probably me at this point in time. And the last one is legal activity. The test is, will say legal object. I still don't know why, but it means the activity must be legal. Otherwise, it's not enforceable. The key here, though, is this applies whether it's oral or written. This applies to all contracts. So you'll get a test question that will say, which of the following is not an element of enforceable contract? And your answer is a signature, because oral contracts do not need to be signed. Now remember, insurance contracts have to be written. That's totally different. Now the features or characteristics are going to be unique to insurance contracts. Will be adhesion, unilateral, utmost good faith, conditional, personal, aleatory. So adhesion, the phrases you're going to be looking for is take it or leave it, no negotiation, vague or ambiguous, the courts rule in favor of the insured, or no control over policy provisions. It just simply means the client has no input. They either take it as written or they don't purchase it at all. Unilateral, uni means one side, so one test question say one side, they usually favor one party is making an enforceable promise, or only one party is legally bound to contractual obligations. That's the insurance company. Then conditional means there's rules that both the insured and insurer have to follow, but it basically means if the insured doesn't follow the rules, the insurer is not obligated to pay, even though there is a contract in force. Personal means the contract is between the insured and the insurer, and it also means that the insured cannot assign, which means transfer their policy to someone else without the insurer's written consent, which they're highly unlikely to get. Now in your property and casualty test, that will be hit quite hard. In your life test, probably not so hard, because in your life test, remember, you can assign a policy without permission because you're a policy owner, not a policy holder. Now, utmost good faith just means that each side is relying on the other not to deceive each other. Aleatory simply means performance depends upon an uncertain future event, which means a claim. It also means that there's going to be an unequal exchange of monies going on. Now, indemnity has several meanings we already talked about, but indemnity, when it's into property and casualty, also means that the amount paid at claim won't be determined ahead of time. It will be determined at the time of claim, opposite of a valued contract, which a valued contract says right on the face what will be paid at claim time. You'll see valued contracts in life insurance, disability, income, accidental death and dismemberment. In property and casualty, you would see it in artwork, or if there's a total loss, California states that it has to become a valued contract. Now, if you're in another state, you'll need to see exactly how it'll apply there. Now what happens here is an indemnity contract, though it's will be determined at the time of loss. That's your property coverages and that's your health insurance. It also means that In your health side, it means you submit your own claim form, and if it's an indemnity payment, it means it pays a stated amount regardless of what the actual expense is. So all of these you do need to know. They will stress different ones at different times, but the reason you need to know all of them is each question will have a correct statement about all the other three, and you're usually picking which is an incorrect answer. Now, fraud, we're going to move on to that. You look for the words intentional, knowingly, whether it's misrepresentation, an omission, which is an oversight, meaning leaving something out, or concealment. But you did it intentionally. If they say that you did it unintentionally, the test will say that it's false. Now, the test says currently, where will we find the falsification provision? Basically, what that is it's the warning on a claim form that says, hey, if you file a false or fraudulent claim, you're guilty of a crime and subject to fines and imprisonment. Now, we're going to break things down to truths and untruths. So there's only two types of truths when it comes to insurance: warranties. Now remember the words. It won't matter how it's put together. First rule, whether it has to do with warranties or authority of agents or anything else, express means in writing. Implied means not in writing, but it's just as legally binding here. Now, when it comes to a warranty, these are statements that are guaranteed to be true in all respect. Is your building sprinklered? The express warranty, it has to be signed and made part of the actual contract. So it's in some document you signed. And anytime it says relates to past, present, or future, you answer warranty. Now, they're currently bringing up that warranty is an intent to do or not do something that materially affects the risk. That's where they come up with breach of warranty. Let me give you an example. When you take out a boat owner's policy, basically you could be saying, I will only sail on inland and coastal waters. Well, if you take it out deep into the ocean, you'd have no coverage. You would be violating the contract. Now, the second type of truth is representations. Now, life in the A&H, which is the class of disability, does not have warranty statements. Everything for them is going to be to the client's best belief in the absence of fraud. In property and casualty, you have both warranties and representations. But representations are oral or written statements, but they're to the client's best belief or knowledge. Now be careful, because they will say guaranteed, and you stop reading and you answer warranties. Guaranteed to be to their best belief or knowledge. Now these are made at time of application or before issuance, which means they can only be altered or withdrawn prior to issuance and not afterwards. Now, what happens here is a representation to the future could indicate a promise, and usually on the test is a representation can qualify as an implied warranty. Not written, has to be implied. And what it means here is you took one of your beliefs and you took it so far that you're practically guaranteeing the client this is the best policy, there's nothing out there. Well, it could be elevated to the standard of a warranty. Now, untruths are concealment and misrepresentation. The difference is concealment means you didn't say anything. You kept silent. So it would be the phrases you would look for is not communicating, silent, failed to disclose, withheld, but information that should have been communicated to the other party. If it's material concealment, which whether it's intentional or unintentional, the injured party can rescind the contract, which means either the insured or the insurer. Now, you don't have to do it intentionally, meaning you forgot to tell them something, but material means that had they known it, they would have, either side would have made a different decision. Now, what happens here is if there's no inquiry, there can be no concealment. If I don't ask you about your driving record, how could you be concealing it? Now, we are not required to communicate something the other person already knows or should know, or it's immaterial or waived or admitted. We only have to communicate relevant facts, not opinions or judgments. Excuse me. Now, Misrepresentation is an oral or written representation that's proven to be false. So they will use the words erroneous or unintentionally erroneous, or false means that the facts did not correspond with assertions or stipulations, I apologize, which means it didn't add up. Now, if the misrepresentation is material, it means it mattered, then whoever was injured, the insured or the insurer, can rescind, means void the contract. Now, materiality, I keep saying, as mattered, that's what materiality means. It means that not knowing the information placed you at a disadvantage, whether you're the insurance company or the insurer. A disadvantage means had you known it, the insurer would have made a different decision about issuing, or the client would have made a different decision about purchasing. Now, it's based on influence of facts, not events. Simply means we don't have to wait for a claim to happen. And materiality is judged the same whether it is a representation, meaning something you said, or whether the representation is a misrepresentation, or whether it's concealment, meaning they both means did they place you at a disadvantage. Boy, I barely got that part out. Now, what happens here is you need to know that producer misrepresentation is kind of different than your clients. So you are not to misrepresent policy terms, benefits, or future dividends, and they usually go for the dividend part, and they make it really easy for you to fall into the trap. Your company has never not paid a dividend. This would be advantage to explaining to your client, well, no, that would be misrepresentation, which is a violation of unfair practices. But it sounded logical, but you cannot lead the client to believe or expect to get a dividend. Twisting is only done by producers, and it either means that they concealed, they misrepresent, they made a misleading comparison, but it induces the client to drop what they currently have. So they'll use the words lapse, forfeit, surrender, if it's in life, reduce the coverages, or it could simply mean that cause them to buy from someone else other than you. So agents never say they lost in competition. We say the business was twisted. But both are violations of unfair practices. Both are misdemeanors. The fine is $25,000 and or 1 year in jail. If you knowingly do it, it's 1 year suspension. And if the insurer looked the other way and knowingly allowed you to do it, they get their certificate suspended. Remember, they get a certificate of authority for each class of insurance that they sell, but they would only get it suspended in that one class. Now, rescission, we keep referring to that, means voiding, revoking, revocation, but we can only do that for material concealment, material misrepresentation, fraud, breach of warranty. And when we do that, we are going to terminate back to the very beginning as though it never existed. It's a flat cancellation. But if it's not one of those, we cannot rescind a contract. So they like to say that we are rescinding the contract because we incurred no liability. Well, no, that means we didn't have a claim, so we're voiding the contract. That doesn't make sense. Or we can rescind the contract because we have a change in underwriting. No, because we'll non-renew them, but there was no material misrepresentation, concealment, fraud, or breach of warranty. Now, waiver is a legal abandonment or relinquishment of a known right. So associate waiver with right. And that just simply means you allowed the client to get away with something, which stops the insurance company from reasserting that right because you had waived it. So waiver comes and goes on the test. Estoppel is usually a multiple choice answer to eliminate. Now, there's 6 policy specifications according to the code. Now, what happens here is all contracts have to state who's the parties. That's the insured and the insurer. What risk is to be insured? Property or life. And What's the interest in the property if you're not 100% owner? What risk are we insuring against for liability for property, or we insuring for death, or are we insuring for disability, or are we insuring for illness or injury? Then we have to state the policy period and the premium. Now, in property and casualty, we do not have to state the insured's address. That's not a requirement. What's a requirement is where's the risk located, meaning the address of the risk. And life and your property and casualty and A&H, we don't have to state the rating of the insurer. And you'll also get a test question. This is required by whom? So you'll get a test question that says that which of the following is or which of the following isn't a requirement. Now we're going to take an opportunity and we're going to pause right here, and you're going to answer these questions. But not only do I want you to answer them without looking, I want you to indicate the keywords, use a pencil, then we'll go over them. So we're going to pause right now. Go ahead and answer them. Fudging and waiting for me to give you the answer kind of defeats the purpose. Then you're memorizing and not learning. All right, we'll pause right now. Now, hopefully you've done what I asked and not waited for me to give you the answers. So in number 1, the blank is consideration. Now remember, consideration is when the insured pays initial premium, completes the application, and it includes the statements, representations, or disclosures, any one of those words in the app, and all the insurer does is promise. So break it down. Money, app, answers. And think about it, the insurance company has to review the answers or consider the answers before they issue. But the only person making a promise is the insurance company. Now, 2, if we enter into a contract with a minor, it's binding on both parties. False. A minor can void it, but the insurance company can't. So if we make the mistake, we're going to be stuck with the contract unless the minor voids it. That type of situation, when one side could void it and chooses not to, means it's a voidable contract. But a contract that is void means that it was never legal in the first place. Now, the number 3 says, judge ruled in favor of the insured due to policy vagueness or being ambiguous is another word they like, is an example of a contract of, and your answer is adhesion. Now, that's being nice. Sometimes the test is really way out there and it'll say, judge ruled in favor of insured, semicolon. You just answer adhesion. Now, 4 says, performance depends upon an uncertain future event as well as an equal exchange of money, describes aleatory, true or false. Well, what happens here is it's false because it should say unequal exchange of money. Emphasize, double underline that, because that's where they get on the questions. They leave unknown for known or vice versa, or they will put equal instead of unequal or unequal when it should be equal. So watch your UNs. Now your next one is going to be 5, says a blank contract is when only one party, so the key there was one party. That's a unilateral. So a unilateral contract is when one party is legally bound to contractual performance. In the insurance industry, the only person making an enforceable promise is the insurance company. The client is just choosing to pay the premium. Now then 6, take it or leave it, equal exchange of money, insurable interest are all characteristics of an insurance contract. False, because once again they left off unequal, not equal. Now 7, both parties rely on statements or disclosures made to each other. This is said to be a contract of utmost good faith, UTMOST, good faith. Now 7. I'm sorry, I did 7. Let's go to 8. Now, the principle of indemnity keeps insurance from being a form of gambling since it prevents the insured from profiting from a loss. That's a true statement. And 9, oral or written statements to the client's best belief, but not guaranteed as true in all respects, describes representations. Key words there were best belief. all right, and not guaranteed. Now, 10, a material stipulation in a contract that if breach voids coverage is called a warranty. Now remember, that would be an intent to do or not do something. That would be a material stipulation. And the next one, blank, can relate to past, present, or future. That is also warranties. And if you found yourself once again being disorientated and going blank, that's because you're not used to having the same answer twice in a row. And that does happen on your test. Now 12, an insured can cancel a policy only when concealed facts are material to the loss. That's true. And what that means here is concealment must be material. Misrepresentation must be material, meaning that it mattered. It placed one party at a disadvantage. Otherwise, the clients conceal and even have lies in the application, which is part of the contract. But if it doesn't change the insurance company's mind about issuing, it's not material and it doesn't void it. Now your next one says withheld, failed to communicate, failed to mention. Those are all phrases for concealment. Now 14, it says blank is judged by keyword, underline disadvantage, placed on the other party by not informing them. That's materiality, which means did the information matter. Also, disadvantage and materiality, put them together. Now 15, materiality doesn't apply to health insurance. False, it applies to everything, because information that matters, it doesn't matter what type of policy we're issuing, we always take that into consideration. 16, parties, meaning insured and insurer, risk insured against, interest of the insured in the property, or could be life of someone, are 3 of the 6 required specifications would be the correct answer. Now 17 says the insured's address and rating is a contract requirement according to the code. False. Remember, if it's property insurance, the address of where the risk is located is what's important, and whether it's property and casualty, life, or A&H. Rating of insurance company constantly changes. Now 18, statements that are guaranteed as true in all respects are called warranties. And 19, in reference to an insurance contract, representations and warranties are made either at the time of application or before issuance of the policy. Now, so it would be or before policy issuance. Now 20, if a person gives an erroneous statement on an application unintentionally, believe it or not, your answer is false. They'll say frivolous, fraud, false, and something else. They're all F's. Now your next one is 21. An insurance representation can qualify as an implied warranty, not expressed, implied. It means you're so insistent that this is the best policy that you've gone from a representation to guaranteeing it is the absolute best. And remember, there is no bigger, better, best. What policy is best for one person is not best for another. We always have to tailor to what the client's needs are. Now your next one is going to be, unless it is merely a statement of expectation, a belief, a representation, keyword, to the future could be a promise. Now then 23, if there has been material misrepresentation or material concealment, the injured party can rescind the contract. Now don't get confused on the test, because they will say the insurer, which of the following is incorrect, the insurer did fraud, the insured did fraud, whatever. When the insurer does fraud, it's not the insurance company, it's the agent. And remember, agent represents insurer. So either side could do material misrepresentation, fraud, or concealment. Now the next part of this is going to say aleatory. Oh, I'm sorry, I went ahead of it. 24. An insurance contract is a written instrument in which a contract is set forth, or they could say written instrument in which a policy set forth, or they can say a written agreement instead of the word instrument. All of those would work. The key is it has to be in writing due to its complexity. Now 25, aleatory, unilateral adhesion, or what makes a contract an enforceable contract? No, those are features or characteristics. What makes it a contract is ACCL, agreement, consideration, competent parties, and legal purposes. All right, the others indicate unique features that are an insurance contract, not all contracts. Now 26, materiality of a representation is judged the same as materiality involving concealment. The answer is true, meaning did it place the other party at a disadvantage. Now 27, every express warranty, now express means in writing, made at or before policy execution must be contained in the policy itself or in another instrument signed by the insured and made part of the policy. That is a true statement because your signature is guaranteeing that it's true. Now the next part of this, 28, says right to information of material facts may be waived either by terms of the insurance, that should say or, but the test will say to, okay, or neglect to make inquirers as to the facts. Therefore, there can be no concealment if there's no inquiry. True. So the key words there is simply going to be neglect to make inquiries. All right. Now your next one is 29. Legal abandonment or relinquishment of a known right is a waiver. Now they can use abandonment, they can use relinquishment. And that simply means you told the client, no, we don't need to look at the car, go ahead and get it fixed. The minute you do that, your insurance companies are stopped from them having to get them to appraise it before they fix it. Now your next part of this is going to be the intent to do or not to do something that materially affects the risk that's going to be a warranty. So that goes back to breach of warranty. I will only sail on inland waters, or you will keep your burglar alarm system on, and if it's not, you're not covered for the peril of theft in commercial. Now 32, let's go to 31. Says when one party intentionally, that's the key word, provides false information in order to benefit from unlawful gain, this is considered, that's going to be fraud. Intentionally or knowingly, you associate with fraud. Unintentionally or erroneous, you associate with being false. Now 33, the 6 required specification for all insurance contracts. Oh, I'm sorry, I missed the other one. So let's go back to 32. I bet some of you are worried about that. Now, insurer is prevented from reasserting a right previously waived or from changing the conduct that the insured has begun to rely and act if doing so would be harmful to the insured is estoppel. Means, remember, we are judged by our business practice, not by what the rule book says. Now 6, the 6 required specifications for all insurance policy is required by whom? The answer would be the code, or CIC, California Insurance Code. Now 34, contract in which one party, all right, promises to indemnify another against loss from an unknown event. Well, what happens here is that is insurance. And 35, upon inquiry, okay, here it says upon inquiry and producers must, upon inquiry, give an opinion or judgment. That is horribly written, but it basically says upon inquiry, producers must give an opinion or a judgment is what they're going for. The answer is false. They must give relevant facts, not opinions or judgments. See how it can be poorly written there? Alrighty. And last, what rule is used to determine the importance of a representation? The answer is the same rule for the importance of concealment. That's your answer, which means materiality. Now we're done with this section.